All right. Yeah, no notice, and we're gonna cover the I think we should. We're gonna cover the jury instruction conference because
Yeah, because for those of you who don't find it boring, it gives us a lot of insight as to the judge's thinking and obviously everything the jury is going to hear to decide what they need to decide.
exactly. And it's super important.
I find it interesting, but
Yeah, but we're
I'm one of the few, right?
So yeah, all right. Okay, let me pull this up. Get this guy going here.
I think I had it paused under your.
All right, let me see. Okay.
This looks perfect.
Wait, we gotta flip you to the other side.
No, oh, that's perfect. I like it like that.
I like it like that.
I like it like that.
Let's see. All right. I don't know how to flip us over.
Here, I'll do it for you, babe.
Wait. Boop.
Okay.
Yay. Oh, wait. Let's see. I got to make this bigger. Boop. Boop. Oh yeah. All right. There we go. All right.
So skilled with the digital. Yes.
There's no request of
can you hear her?
Included. Testing that.
That's correct, Ron.
Okay.
Do you hear her?
Yeah.
All right. Okay. So
did we miss anything? Because
no, this is
mid sentence.
All right. Wait. Hold on. I'm not hearing it. So let me
do that.
That's correct, Ron.
Okay. And
I think it's my wait, hold on. Let me
neither side has requested an instruction.
See, I muted it
of a lesser included of OUI.
It's correct as well.
And the defense is not requesting
that arrow button.
Okay. All right.
So did you mute me too, babe?
No, I didn't.
Okay.
I'm trying, but honey, I got from my end because I'm streaming it. So I have the sound coming through twice. I have
the
to figure
request
out
from the defense is that I split the charge, and it's written that way. I'm not going to split.
Do you hear
the charge?
Like, I'm trying to figure out if
the
you
way it'll
hear.
Be is the defense will argue first, then the Commonwealth, and then I just go through all the instructions. So aside from that, the first instruction is presumption of innocence. I have one that I typically give, but I will give the one.
Get it right back to right where she's starting. People walking in.
You are unmuted.
All right, now let me figure out.
All right. So the charge conference. The first question I have is regarding I'll go through them in the order that I have them in my very rough draft. But
can you hear her?
Yes.
Yeah. What the hell? Like, I'm not hearing her.
She's not saying anything.
There's no request of the lesser included offense of voluntary manslaughter to the second degree murder charges. That what the Commonwealth's intention is, not to request an instruction on voluntary manslaughter?
He should absolutely
as a lesser included of the second degree murder.
Want the conviction.
I'm sorry.
No, because we're really firm. We believe we're going to get our guilty.
That's correct, Ron.
Okay.
I pause it right there, Bay.
Okay, hold on.
Neither side has requested an instruction.
I'm still working through some things, honey.
Of a lesser included of
like what you're not getting is I can't hear her.
That's correct as well.
All right.
You can, but I
can't. Is not requesting
which is weird because I have it like up.
All right. So.
All right, now let me see if it's double for me now. Okay, there we go. See, I always have some other shit.
All right.
Oh,
so the first instruction, the request from the defense is that I split the charge, and it's written that way. I'm not going to split.
Sounds like I'm not going.
So the way it'll be is
maybe not.
Okay.
The defense will argue first, then the Commonwealth, and then I just go through all the instructions. So aside from that, the first instruction is presumption of innocence. I have one that I typically give, but I will give the one that's
okay.
So the first thing she asked is if anybody wanted a lesser included. Now, oftentimes the Commonwealth, the state, won't want a lesser included because they don't want to give the jury an avenue out. They want that higher conviction. The reason in this case I'm saying I think he should have asked for it is because, at least the way I see it, and If I'm wrong as far as what this jury comes back. But at least the way I see it, there's not a lot here. There's a very huge risk here that the jury could come back not guilty on all counts. And with that being the case, you would think that the Commonwealth would want to give them alternatives. In this scenario, I'm not surprised that the defense does not want to be asking for a lesser included, because they also don't want to give the jury a way to find her guilty, even though they don't agree with most of what the Commonwealth even though they might not agree with what most of the Commonwealth has presented, or that they have sustained their burden of proof as to the charges that are before the jury. So to that sense, I am surprised. They also didn't just throw in DUI. I mean, look, you want something, damn, throw in the DUI, or DWI, as they call it there, which is driving while intoxicated as opposed to driving under the influence. So that's all that we have heard thus far. And now she's going to get into the very specific instructions. And I'm assuming that she'll kind of flip forward very quickly as to those that, are very commonplace and are, there's not going to be any dispute over. And then we'll have some comments and then some commentary on the things that are of issue.
All right, cool.
Requested by the defense. Next instruction is our reasonable doubt instruction. Then function of the jury, the arguments of the lawyers and the judge's comments, function of the judge, functions of the lawyers. Verdict must be based on the evidence. I've incorporated some of what you've both included into that. I have language here that similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try and guess what may have been removed or why. I think that came from the defendant's request. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence.
Jay's probably not going to cover. So we were discussing it. Jay finds jury conference or jury instruction conferences to be, I think his quote was, boring as fuck. So
it doesn't allow for much comedic relief.
Yeah, it's
Jay sees it.
But from the side of the law, and for law nerds, this is one of the most critical things that happens in a trial. These are literally the guideposts for the jury when they get sent back. This is what they're going to determine innocence or guilt on, or guilty or not guilty on. So we think they're important. They are a little dry, but they're interesting, and Allie will do a very good job of explaining them. Allie was always, in all of our trials, was always the one to argue the language in jury instructions, because language matters. Every word counts in instructions, and Allison was hyper vigilant with doing that. So we think it'll be interesting. Let's check it out.
Evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to the questions and exhibits, are evidence, with a more robust instruction, but that's what I've added. And I do have a line about sympathy. Then I do the view. I should say right off the bat, I am not going to give a Bowden instruction. You can argue it. You've been able to put in a tremendous amount of evidence. I've given you a lot of leeway with that. But there is something in this case that and I'm fully within the law to do that. So I have here some language that I think is appropriate based on issues that were raised about the credibility of witnesses. Did the witness have any bias, reason, or motive to give false?
All right. So the last pause for a second. So Donna, yes, you missed. So cases is basically at the point where both sides have rested. The defense just put on 3 witnesses today, and they rested. The state or the Commonwealth had no rebuttal. So right now we are in the jury instruction conference where the judge is basically going to be deciding what instructions are going to be read to the jurors. And at that point, tomorrow morning, each side has been given an hour for closings, and then it goes to the jury. So that's where we're at.
Or shaded testimony. If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the evidence presented. So
All right.
I cover the bias part of that.
So
Let me
she's,
pause it.
yeah,
And
she's
we'll
not,
go through and you can tell me.
she's not giving a Bowden instruction. I wonder if that's like their technical section 1107 inadequate police investigation evidence. The instruction could have been evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated in circumstances in which it was reasonable to expect the police should have conducted such tests, followed such procedures, or investigated such information is admissible. They also note that the admission of Bowden evidence, which again, Bowden evidence is different than third-party culpability evidence. Bowden evidence speaks to the inadequacy of a police investigation. So it does say in a 2003 case, the admission of Bowden evidence does not require the trial judge to give a special instruction to the jury. Instead, the jury is simply required not to take the issue of the adequacy of the police investigation away from the jury. And then they do have a actual Bowden instruction, omissions in police investigation. Now, this is from their 2009 edition of their instructions. Let me just make sure. Yes, and this is from mass.gov. And it says, you have heard some evidence suggesting that the Commonwealth did not conduct basically the same thing, certain scientific tests, or otherwise follow standard procedures during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the tests or other actions. If you find any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. So with that said, what I suggest is, Bob, you rewind and let's hear again what she has decided to allow in that she says covers, quote, bias.
Who's going to argue? And I'm giving you a wait. I am not going to give a Bowden instruction. You can argue it. You've been able to put in a tremendous amount of evidence. I've given you a lot of leeway with that. But there is something in this case that I'm fully within the law to do that. So I have here some language that I think is appropriate based on issues that were raised about the credibility of witnesses. Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the evidence presented. So I cover the bias part of that. And we'll go through and you can tell me who's going to argue this for the defense. Okay, so we'll go through and
there's argument coming.
The limiting instructions, I give the defendant's bad acts instruction. I'll give a similar instruction on the digital evidence that I did during the trial, photographs and testimony with an emotional impact, humane practice, and as of today, hypothetical. I had hoped that both of you could suggest something. I said that this morning. Do either side have anything for me on hypotheticals?
I'm sorry, I don't, Your Honor. We're going to be getting back at a fairly early hour. I'm happy to work on it.
That's fine. I mean, I can do it, but I wanted to give you both the opportunity. Yeah, go ahead and do one and send it to me.
I'm happy to do that.
I'll have one too by the end of the day.
Okay, thank you. All right. Opinion testimony, evaluation of exhibits, direct and indirect and circumstantial evidence. So I received today defendant's request, a late request for the law allows both direct and indirect evidence, and there is no distinction to be given. A conviction, however, may not be based upon the piling of inference upon inference or on conjecture and speculation. I don't think that's exactly the language from the case law here that you've cited. There,
I actually quoted it, Your Honor.
so from which one? From Haunch or?
Haunch quotes McCormick, and McCormick takes the law from doesnt. There are
Yeah, so,
multiple cases that
right, and the language that is typically given on this piling that I haven't really seen in years is you should not pile inference upon inference until the pile gets so high that it tips over logically or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure they're still reasonable. I mean, I could give that old language. All right. That's,
prefer that.
I haven't given that in years, but I'll give that part of it. And just to finish off that paragraph, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and reasonable inferences that you have drawn taken together prove that she is guilty beyond a reasonable doubt. Okay, so that rounds off that. All right. All right, so now we'll talk about the indictments and the lesser included. So the second degree murder instruction that was provided by the Commonwealth and the one provided by the defense are just a little bit different. So if you take what was provided, there's one section that the defense incorporates that I think is missing from the instruction, and I'm going by the SJC instructions. So when you get to the second element of second degree murder, the defendant intended to kill John O'Keefe, the second element, first prong. So the second element is that the defendant intended to kill John O'Keefe. As you can see, the second element has three sub-elements. I'm reading from the Commonwealth's proposed instructions, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill. Now here, I am going to insert, because if you go back to the SJC instructions, I think it is appropriate to go back to the instruction on deliberate premeditation, which is the second element of that, is the language that is offered here by the defendant, that the defendant consciously and purposefully intended to cause the death of John O'Keefe. So who's arguing this for the Commonwealth? So Ms. McLaughlin, does that make sense there?
Yes, ma'am.
Okay, so I am going to put that in there. All right. And the defense has the language of accident there, but Mr. Yannetti, that really goes at the end. That goes, as you'll see if you look at the instruction on extreme atrocity or cruelty, where you have to go. So that'll go at the end. That will go after the third prong definition. Then I will include the language that I think the Commonwealth put in its request. It goes there. If you have a reasonable doubt as to whether the victim's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have created a plain and strong likelihood. Then you have in deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. You may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol or drugs. That goes there.
That's fine, Your Honor, with us.
Okay, does that make sense to you too, Ms. McLaughlin? Okay. All right, do you want both the mental impairment or consumption of alcohol and drugs? Oh, do you want to just leave the whole generic sentence?
I think we can, yes.
Is there any objection from the Commonwealth on that?
I don't believe there's any evidence of mental impairment, but the Commonwealth has no strong objection.
All right, but there's no evidence of drugs either, so do you want it to just be alcohol?
I suggest that would be most in line with the evidence, just to have intoxication under alcohol.
All right, it makes sense to me, Ms. Giannetti, if we focus just on the alcohol, but if you wanted the mental impairment, I'd include all, but.
I would prefer just to keep it in this jump as
All right, so I will think about this one tonight, okay?
He wanted to leave it.
Okay, then manslaughter while operating a motor vehicle under the influence of liquor. So, Ms. Giannetti, you have included in the language, what does it mean to be under the influence of alcohol? That paragraph that starts after the third element? Yeah.
I'm sorry, Your Honor, is there a page number on from my?
9.
Big Mac? I have it, yes.
All
Sorry.
right, so you have included, it means that a person has consumed enough alcohol to reduce their mental clarity, self-control, and reflexes, and thereby left them with a reduced ability to drive safely. Where is that language from?
This particular portion, I thought was from the model instructions. If I'm wrong, then we're fine with model instructions on this issue.
All right, what does the Commonwealth say?
I'm looking at the
The
model. I
Commonwealth's
don't-
language comes from the model and jury instructions, I believe, from the most recent 2024 instruction on intoxication.
And that's not in the Commonwealth's request, correct? That sentence I just read?
On page 5, third paragraph, it's either a similar sentence or a
Yeah, it's a similar sentence, and I was just having both. It was, a person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected or emergencies. So we don't need both, Ms. Giannetti.
I agree, Your Honor.
So you had both, so I'm just not going to do that,
We're perfectly fine with that.
okay? So under the second theory, so the Commonwealth is proposing the theory of the 0.08 or greater. The evidence supports that. I'm going to do that. So in the language from the Commonwealth, the fourth element. Now then we talk about wanton and reckless. So for the fourth element, Ms. Giannetti, this is where your language. You have language for 5 that actually belongs in 4, I think. I'm just going to find it. On the foreseeability, I think that belongs under 4. And that's where I'll have it. Okay? Belongs at 4 instead of 5. Do you agree with that, Ms.
No, yes, that's fine.
Okay, do you agree with that, Ms. McLaughlin? It belongs under 5?
Yes.
Okay. All right. So I'll keep it. I mean, it belongs under 4. I'll keep it at 4 and not have it at 5 where you put it, Ms. Giannetti, okay? All right. I am going to give the lesser included offense of involuntary manslaughter. So there's additional language that I have found helpful in other cases. When I discuss the language and the cause of death, remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. And then the next sentence is a defendant's act is the cause of death where in a natural and continuous sequence results in death and without which death would not have occurred. Okay, so those 2 sentences I find go better together, Ms. Giannetti. Is there any objection to that?
No, I understand.
Okay, any objection from the Commonwealth? So, Ms. Giannetti, you have in here a police officer's opinion about a driver's sobriety, like that testified to in this case. A police officer didn't testify as to the defendant's sobriety. So,
I think you're right.
so okay, so that paragraph that begins with that, we'll just cross that out.
I think that's fine.
Okay. In this same instruction, I have included in the paragraph, in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another. Some portion of the sentence that I'm going to think about tonight, I have, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol. Okay. Any objection from the Commonwealth on that?
No, Your Honor, that was requested by the Commonwealth. If you can consider it, please.
Yep, so that will be in that last paragraph of that offense, Mr. Yannetti.
Why is she talking to Yannetti?
Okay, then the
Miss
lesser
Little
included
talks.
offense, motor vehicle homicide, felony OUI, liquor, and negligence. I'm going to give that. So I don't have anything because you didn't, the defense didn't propose any lesser included. So I didn't see anything that was inappropriate about the Commonwealth's instruction, Ms. Giannetti.
Fan mail.
I've added, I think,
Yeah,
one line that a person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under
Thank
the
you, Dawn.
circumstances, or by failing to do something that a reasonable person would do. It's obviously the law,
down,
right?
down the
Right,
rabbit
yeah,
hole.
that's the law of negligence.
Thank you,
And I do
Dom.
understand the law of lesser included and, you know,
Okay,
right, I think that.
all right, thank you. So
I mean,
the-
Bob, you may be pitiful, but
leaving the scene of an accident resulting in death. So what the Commonwealth has provided is basically just the 6th 6 elements with nothing further. They're pretty much 1 and 2 have already been defined for the jury many times at this point. 3, the defendant knowingly collided with John O'Keefe. I think that's self-evident.
Yeah. Beyond a reasonable doubt, please, down the rabbit holes.
So, Ms. McLaughlin, why don't we start from here? Why did you just give me the 6 elements?
Your Honor, as you suggested, the first 2 have been defined extensively for the jury, and I believe the other 4 prongs are self-evident, and they don't need further instruction.
Yeah.
I think it would be
Babe, you can unhighlight her comment.
redundant
now.
or
yeah.
unnecessary to explain to a juror what failure to provide documentation of registration and things like that does not warrant additional instruction.
Do you think they need to listen to me any longer than necessary, Ms. Giannetti?
We're in complete agreement, maybe for the first time in this.
All right, so we'll just leave it. You've offered 6,
So she's just saying they gave
2
just
pages
the
or 3
elements.
pages of definitions, so we won't do that.
So they're not worrying about
Okay.
definitions when it comes to the leaving of the scene of an
All right.
accident instruction.
Ms. McLaughlin, the use of a dangerous weapon, a motor vehicle, I agree that's an appropriate statement of the law. Tell me about your request to have that.
Your Honor, the request goes to the defendant's state of mind. Also, it would go to any intent or any understanding of the jury of what would be reckless conduct or negligent conduct or intentional conduct. If they understand that the use of a motor vehicle to commit a crime could be a per se dangerous weapon, and in using that to strike an individual, that could be used in their deliberations, assessing the defendant's intent or state of mind at the time of the collision.
It seems to make sense, Ms. Giannetti.
My position is it's unnecessary, but I'm going to waive argument beyond that.
Okay. All right. I think it makes sense, and I'll just leave it sort of as a catch-all at the end where it appears on the Commonwealth's request. All right. So that's basically it. The longest part maybe is the general instructions in the beginning. Anything specific from the Commonwealth that I did not include?
Do you intend to give a conscience of guilt instruction?
Oh, I'll hear you on that.
Yeah, I'll hear you on that too.
I don't, but you can try and convince me if you want.
There you go.
Your Honor, the Commonwealth would put forth that there's been sufficient evidence that the defendant has engaged in actions that go to a consciousness of guilt. There's an inference that the defendant deleted portions of the ring video, a narrow area of ring video portion of ring videos that are missing. They begin with Mike Camerano picking up his daughter at 11 a.m. They resume at 5:07 when the defendant backs her vehicle into John O'Keefe's. Then there's a period missing where the defendant shows the broken taillight to Jennifer McCabe and Carrie Roberts, and then the video resumes again when the victim's niece gets picked up. But not only the missing ring videos, but also the defendant's behavior. What began as testified to from the Dighton police officer, the defendant's father called the Dighton Police Department and requested a ride to the Good Samaritan.
All right, if y'all are jumping in late, what they're doing right now is what's called the jury instruction conference, and this is where the sides argue about what instruction should be tendered to the jury. The judge goes through them all. She's going to go through them all, and then ultimately she'll land on whichever one she thinks is proper if there's some kind of dispute between the Commonwealth and the defense. Right now, the Commonwealth is trying to get in the consciousness of guilt instruction, so that's what they're arguing right now.
And let me just say, in the 2024 revised instructions, they've got 5 types of consciousness of guilt. Flight, so that obviously that they fled after the scene. False statements, make an intentional false statement. False name, giving a false name. Evidence tampering, which is what they're speaking about right now. And witness intimidation or bribery. So this is all going to go on evidence tampering, and I'm not sure if they're going to make some argument about a false statement. I'm also surprised that there hasn't been any argument yet about confessions or statements, since they Sorry, I got the hiccups.
And I mean, I think she's wrapping it. Like, I think it's a pretty short, like, she's not going through all the mundane instructions that you'll
No, they're going over the ones that they fight about. So
Right.
I'm surprised there's not more argument on the voting, but maybe, I don't know, maybe there will be.
Yeah, I think they said they were going to submit something in writing. It sounded like.
Hospital due to the weather conditions. He then drove himself to Brockton to pick up the defendant and perhaps bring her home. What they do in the middle of a blizzard is now Dighton to Brockton is half a distance. Then they travel further all the way back to Canton to retrieve the murder weapon, along with the defendant's brother. They all meet at the victim's residence to remove the murder vehicle and bring it all the way down to Dighton, Massachusetts. That would go to concealing evidence and intentional. There's also evidence of the defendant's statements going to her consciousness of guilt within hours after John's death. The victim's sister-in-law calls the defendant, reaches out, wants to make sure she's okay. The defendant says to her, "I only have to remember the bad times. You'll likely never hear from me again." Erin O'Keefe testified that she tells the defendant, "Of course we are, we're friends." She's never heard from the defendant since. So I think that goes to the defendant's state of mind in the hours after the death. But in addition to the ring video, I think there's strong evidence of consciousness of guilt to move the murder vehicle within hours of John's death.
Ms. Giannetti?
Yeah.
Well, first of all, with regard to the ring video,
The evidence says
certainly no friend
cops
of
did it.
defense in this case, testified that there was zero evidence that Karen Reed had access or had access anything on that computer, and the Commonwealth utterly failed to prove that she had any access to delete anything. So I would say that that is a red herring. This is the one case, I think, a very rare case where there's much more consciousness of guilt evidence with regard to the Commonwealth's own witnesses than there is with regard to the defendant in the case. With regard to the
Seems quiet.
Does it? I put the volume. He's not in front of
So
the mic.
the moving the car extra distance during a blizzard, that part of the argument that the Commonwealth made.
Right. I mean, the evidence was that my client maintained a residence in Mansfield. She didn't live at One Meadow. She spent time there. To say that moving her car to her own home, where the police later found it because she was there and picked up the phone and said that the police were coming and she stayed there and they were able to seize the car, that does not rise to the level of consciousness of guilt.
It does not.
The defendant actually moved her vehicle to her parents' residence, so that indictment, not her residence in Mansfield, which would further support an inference that she was concealing evidence.
But well, even if it's her parents' house, Your Honor, again, if she's no longer dating John O'Keefe because he's passed away, then it makes sense for her to have her vehicle at her parents' house or her own house. Again, it does not rise to the level of consciousness.
It doesn't.
Nor does she stay at the home of her boyfriend to grieve with the family who just lost John. She quickly comes back to the house, brings her family members, goes upstairs for about 20 minutes by herself with her father, and quickly leaves the residence.
There's no evidence that she did anything upstairs or that she had access or the ability to change anything.
Okay, it's a little bit more robust argument than I expected from the Commonwealth, so I'm going to think about this. I'll let you know before closing argument tomorrow, and if I don't instruct on it, Commonwealth's still able to testify to it.
You mean argue it, Your Honor? Jeez.
Witness pretrial preparation, that came out on both sides. I'm going to give the second alternative.
We have
Okay,
lawyers are allowed
you on your
to
instructions.
instruct witnesses. Instruction.
I believe that we covered the vast majority of it, Your Honor.
I'll give you the opportunity to argue the Bowden one, just so you can make a record.
Sure. All right, let me just pull up.
I'll find your page.
Okay, so yeah, with regard to the Bowden evidence or instruction, Your Honor, having done this for as long as I have, It's requested a lot and not given, a large percentage of the time. And I do recognize that the court has discretion to give it or not give it, and that we also can argue this is voting right.
Right.
But, I think that if there's any case where a voting instruction should be given, it's this one. We start with the conflict of interest that existed at the start of this case, and the fact that Michael Clarkman was allowed to not only continue with the case, but to be the lead investigator or police officer during the whole pendency of the case, despite his obvious conflict of interest with the Albert family. We then move to the fact that, he never, as a lead investigator, went into the house at 34 Fairview. He never looked around. He never checked for any signs of struggle. He never checked out the basement. He never looked for a weapon that could have been used to do the damage that was done to the back of John O'Keefe's head. He never once asked about Chloe, the German Shepherd, despite the obvious injuries to John O'Keefe's mind. With regard to the witnesses, Your Honor, witnesses were interviewed in a very relaxed manner at their own homes. There was testimony that they were interviewed together, that they were not separated out on numerous occasions. Brian Albert, Paul Albert, John McCabe, Matt McCabe, all interviewed en masse. Later, everybody in that group, except for Nicole Albert, was also interviewed at the same time. Chris and Julie Albert were interviewed together. And then we have all this, evidence, the way it was handled, or I should say mishandled. Starting with the leaf blowers and the solo cups and things being pictured on the floor of garages, but not being properly handled, and the fact that there are no chain of custody laws for the evidence before March of 2022. So I just highlight those, Your Honor, as examples. I believe there's more, but that's the record that I will make.
Okay, so you satisfied you've made a complete record on this?
I mean, so.
All right, but I did include some specific bias language that I read to you early on that sort of ties into this. Okay, so nothing else?
So I have one question. The defendant requested a missing witness instruction.
Yeah, you're not.
I've withdrawn that. That was crafted as the trial was ongoing. I didn't know if we were going to have that or not.
Thank you for bringing that up, Ms.
I
McLaughlin.
agree that it's not appropriate.
Okay. All right, so I will see you tomorrow morning.
Question, Your Honor, is, and I haven't tried this before, I don't think. Do you typically send a copy of your instructions to counsel prior to?
If I have it finished, I expect I'll be up late tonight and won't have it finished in time for you tomorrow. All right, I do give 2, maybe 3 copies to the jury afterwards.
There was some question as to the use of chalks for closing argument.
To permit the use of chalks for closing argument?
So can we focus on this? So does the defense intend to use chalks?
I'm going to defer myself on that. 2.
What do you intend to?
Chalks? Like chalk? You're writing on a chalkboard?
I don't know. Let's see what she says. Like,
Accent thing?
I have chalks. Chalks? I don't know. Hold on. Let's see. Maybe she'll explain it.
Use.
Photographs of the
Charts? Charts. 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 She means charts. 2 Utes? The 2
All right,
Utes.
hit play.
Charts.
Let me hear this.
Charts. Okay.
Charts.
Okay, charts. Correct.
Huh?
Charts. Charts. Chalks. Charts? You don't want you.
and photographs of the taillight. So 2 side-by-side photographs of the taillight that are in evidence, photographs of the vehicle, still shots of the vehicle that are in evidence.
Okay. Okay.
And that's the extent of it.
Okay, Commonwealth, are you using any chalks? Charts or
Commonwealth
chalk?
have any objection?
No, but the Commonwealth also intends to use chalks.
What do you intend to use?
Also side-by-side photographs and video, but also a timeline that summarizes text messages and voicemails and significant events from January 28th through January 29th.
Okay. Any,
The request is I'd like to see that.
sure, you should both exchange them, okay?
Maybe
Judge,
that's
my other
another
question
word
is
for
that
demonstrative.
At one point during the trial, there was a changing of 2 jurors, their seats, just for purposes of their own comfort. The way I pick alternates is by seat number.
So I'm going to ask you not to pick them by seat number, Jim, by juror number, juror card number. They
Okay.
may not remember what that is.
No, I have
No,
absolutely.
they may not.
Okay. They may not know their old juror number.
Their actual 3-digit number.
Right. They may not know that. Do you want me to use it?
No, if they know it, we'll use it. We'll talk about this.
Okay.
All right. Why did you want to move them into? We'll talk about this.
Okay.
All right.
No, when is that done?
At the
At what point?
at the end of the instruction, before I give the instruction on be fair, the SJC instruction on be fair.
Can I ask a question?
Yes.
You pick a full person?
Yes.
Wait,
So sometimes it's done by lottery. I just wonder.
No, so, right. In Massachusetts, it's supposed to be chosen by the judge. So,
she
I
picks
know.
a four-person.
anything
I
else?
need to learn more about Massachusetts law.
Yeah. All right. Thank you. We'll see you tomorrow. Jim.
Board, all rise.
She just picks them willy-nilly, or she picked them. I don't like that at all. I don't like my judge picking my foreman after she's been
they've
able to
done it
see.
in quite a few trials. They did it in Murdoch,
But
Newman.
At the end,
Yeah. Well,
like after they've
right
been
after the instructions, they
monitoring their face, they're like, oh, I'm going to go with
yeah.
you.
I've seen a
Wow.
couple. I've seen a couple few in a row where the judge was selecting the four-person. So
That's wild.
I mean, I
That is
kind of
wild.
like that though. If you think that concept out,
I do, but I like it in the beginning. Before she's got to write it down and tuck it in a little envelope
why?
so that she's not basing it on anything she's observing during.
Meaning that like if she sees like somebody who's super attentive or
Or, yeah.
making some kind of face every time
Ah.
the Commonwealth puts a witness on, or
It's like, I'm
was
not
doing
picking
like
that
the
guy.
gag me thing when Proctor was on, some shit like that.
Right.
Yeah. They don't show her much, but I'm assuming she checks out the jury a fair amount.
I don't know how they
No.
couldn't.
So, all right.
I think we should answer any questions they've got. They've got to have some questions.
I agree.
Hey.
Well, I think what we should also do is talk about, evidence is closed now. What is I want to hear your opinion. Where do you think this is at? Like, remember, there's two separate charges here. Everybody, this isn't a guilty or not guilty, like globally. They could easily find him or her not guilty on the murder too, and find her guilty on the manslaughter. So like it's two separate counts that we've got to deal with here. So where are you at, babe? What do you think?
I think hands down, without like any second thought, it's not guilty on second degree.
Yeah, I agree with that. Like they gave no evidence whatsoever. Intent, and you guys heard the instruction. Intent is an absolute requisite. You have to have it. They have to have proved intent to murder. Not like they didn't even have great bodily injury. Like she just said, like intent to murder him. So,
And with the two last witnesses, I have to say, I don't know if they forgot to renew their directed verdict, if that's not something they do in Massachusetts at the close of the evidence. It's got to be, or if they did it all outside, just off the record or off the, like some sort of in-chamber record or whatever the case may be. But with the last two witnesses, I just don't see how they can find guilt on even. I don't see how they can decide there is evidence beyond a reasonable doubt that vehicle came in contact with any part of John O'Keefe. And that Officer O'Keefe, obviously, that makes them have to decide that everything else is planted by the police.
right. So, I mean, this is what we've got pro Commonwealth, right? We've got her statements. Okay.
I hit him.
You've got, they're claiming, and it's in evidence, that there's these microscopic shards or pieces of the taillight in John O'Keefe's clothing, consistent
I still
with.
don't understand when that evidence came in because
I mean, they certainly didn't harp on it. Like Lally just kind of came in and wasn't like, there wasn't much of a thing. And the defense didn't even acknowledge it, which is probably why you don't think that it came in, but it did. So you've got her statements. You've got the microscopic shards. You got the hair that was found on the vehicle that survived the blizzard. You've got his DNA in the receptacle. Okay, so those are kind of like the big things, right? Those are the main things. They've obviously got arguments.
Were the shards of glass embedded, like that glass was embedded in the bumper where it was just, the witness said, sitting there? Like
what the evidence in, like, you can argue about all you want, but the evidence that got in is that they found microscopic pieces of the taillight, or pieces of plastic consistent with the taillight, in his clothing. So that's in, like, there's no disputing it at this point. I'm just listing what they have, what Lally's going to go through tomorrow, and what he's going to say. Look, you have to believe some crazy conspiracy has taken place, that there's cops out there planting taillight when that's impossible, because the thing wasn't even in the Alexis wasn't even in the Sally port for them to have time to get over there.
Excuse me, sir, but I wonder, where in the hell was it from 4 whatever until 5:30?
All right, I don't want to make the arguments now. Let me just go through. I'm going to tell you like what his shit's going to be. You know, I mean, like, they're going to have a position. What Lally's not going to do, and I'm sure he'll be dry and boring like he has for the entire trial, but he's going to put in their position on this thing. And you know, there's going to be these things where we have to think about whether or not any of them resonate with the juror. You know, because if, like, the one thing the defense did not prove was that John O'Keefe entered the house. Now, they didn't have to prove jack shit, right? But they couldn't provide any witnesses or any kind of testimony whatsoever that he did go in. So, you know, I mean, the jury's sitting there like, all right, I don't know what to do with that, you know, but it exists. You know, we've got this concept. We have the shitty cop Proctor, who's completely unprofessional, certainly seemed to have it out for Karen Reed. You know, how much weight do we give him? You know, you've got this testimony from Carrie Roberts, who I think was a pretty credible witness, who claims that, you know, when Karen called her at 5 a.m. bright and early, that she said John's dead, you know, like before she even been to the house. So they've got some things there. Like, there's some stuff that exists in the world that they're going to put forward. So when we're trying to think about a jury and how they're going to look at it, now we have to look at what the defense was able to put in. And this is why I think it was important for today to have happened for the defense, not so much because they needed to rebut anything that was on the case in chief of the Commonwealth, because, you know, Trooper Paul was just a disaster for them. And the ME, I mean, Scoripello was like a godsend for the defense. I mean, their own ME came back with undetermined and was simply not willing to say that his injuries, the causation of his injuries, were consistent with a motor vehicle accident. I mean, those things are huge for the defense.
Right. And I think in CH's list here, there is no evidence of access to the deleted camera footage. There is zero evidence of that.
Zero evidence.
There's evidence actually that there was no ability to access, nor any access to the camera footage. And that the only people that had access to that were, you know, somebody with his cell phone in the police department after the other trooper wrote it down.
Yeah. I think it will be a catastrophic mistake if,
and clearly they're doing it. They just argued.
I think it will be a catastrophic mistake if Alan Jackson harps or decides to really focus on the 227 Google search. I don't think
he's going to.
I don't think he should. I don't think he needs to. I think that it's a problem for him if he does. That Google search contradicts Lucky Loughran's observations, because Lucky Loughran, and there is no car. I want to be clear. Gone back and listened to that. the edge was not there. The Ford Edge was not there on his first pass at 2:35 a.m. So he had a clear view. He does not see the body. So for the search to have taken place by Jen McCabe at 2:27 a.m., that would mean that you'd have to believe that she was texting, okay, well, or searching, he's still alive. And if we put him out in the cold, how long will it take him before he dies? That would have to be that argument.
That is what their argument is, that they're checking. Like, all right, how long would it take to die if we stick him out there right now?
Is that what well, I didn't hear them argue that.
I mean, that's
in my brain. It was always, oh God, he's still laying out there. He hasn't gotten up yet. What the hell's like? How long is it? Like, he's still there. Like, is he gonna die of like, you know what I mean? Like, that was always in my head. Not that like, okay, Google, because she's like unequivocally at home at that point, right?
Yeah.
So she's at home at that.
Either
point.
way, I agree that I agree that the defense shouldn't focus on that, but they will. And I agree, like the Commonwealth should not say a freaking word one about her trying to delete that footage. It is so insanely ridiculous, but we know they will because she just tried to make the argument to the judge. The judge, when the judge is like, well, there's more to this argument than I thought, has nothing to do with the deleted footage, which there is no evidence.
There's no evidence of that.
She touched the damn
that's
footage.
a non-starter.
Right. But
I don't even think he can argue it. He'd be arguing facts, not in evidence. So, like, it doesn't exist. So, like, but to finish my point, what was big about today, the absolute, and it wasn't Dr. Frank Sheridan. Okay, it was the two witnesses that were not retained by either the Commonwealth or the defense, that were retained by a third party, which we know to be the feds, which the jury does not know. Allison made a very observant point when we were watching like Law and Crime or Law and Order, Court TV, like in between this and jumping on. She's like, well, I think that the jury might think that third party is like a civil suit, or maybe the car manufacturer, or some kind of other, like I agree with her. I don't think that immediately, if the jury truly doesn't know what's going on around,
I would think it.
Right, that it wouldn't be the feds. Like I mean, why would, like, I don't think a normal person would think, oh, well, the feds have now investigated this.
I'm thinking it's the city, it's something about the shape of the roadway, it's the car manufacturer, or it's just straight the parties. And I think the defense,
something dealing with the civil suit.
I wonder if they were able to say to the judge, we want to be able to tell the jury that these people were not hired by anybody looking to prove the safety of that vehicle, just so that they wouldn't be left thinking, well, they were motivated to say that it wasn't a vehicle coming in contact because they were hired by the people who make the rear beeping sound,
Right. So, but to just like round out this thing. So like the fact that these two witnesses came on, to me, were devastating witnesses, like absolutely, because they've just got no skin in this game. Like, they weren't hired by the defense. And Jackson did a brilliant job of highlighting that for the jury. Like, these aren't our guys. Like, I've never even spoken to this dude.
You're
about
not
his
beholden
report.
to me for
right.
anything.
I didn't give you any kind of ideas about our theory of this case prior to you doing your investigation, right? Like, we've never had those conversations. Like, the whole, I'm going to take a glass and blow it out of a cannon. Like you came up with that shit on your own because that's what made the most sense to you. So the fact that you've got these two guys coming on, giving the testimony that they gave, to me, is all that they need to argue in closing. If I'm the defense, I know you would have the urge to go through and like, oh, we got to rebut all their bullshit. I don't think so. I think that all you have to do is say, look, you've heard it all for 30 days. Okay. And you've heard everything the state or the Commonwealth has to offer. You've heard all that we have to offer. And I'm going to suggest to you, jurors, that the only two people that should really make any difference to you are the two guys that got on that stand that the Commonwealth did not call, who had every opportunity to call, and listen to what they said to you. You heard their qualifications. They're unimpeachable. Like, these guys are masters at their craft. These guys are incredibly well-educated guys. And they told you flat out that those injuries are not consistent with John O'Keefe being struck by a vehicle. Period. End of conversation. I mean, to me, that's all there is. To me, that ended the case. I mean,
they should definitely start and end with that. They should definitely be the first words they speak and the last words they speak. And when they devise their little, baby, you know what? I want you to come up between tonight and tomorrow with what your mantra would be, what your opening theme would be that you would use. We could both come up with one.
I'd probably go with my old standby, that great John Adams quote that I love so much. You know, facts are stubborn things. So Creed, so this is interesting. I did not know this. In Mass, the defense goes first and the state only gets rebuttal.
I thought that's what she said. I was going to ask you guys. I was like, is that what she just said?
Wow.
I'm shocked. I'm
Right.
shocked. Thank you, Creed. I thought she said that because, and I didn't know if she was talking about, I'm going to do it this way during jury instructions, or if that's literally what she said. That's wild. That's wild. I've never, ever, ever, ever seen that. So even more than ever, the defense has to anticipate what the state is going to say. And obviously they can anticipate much, but it needs to be, and I think with these guys being former prosecutors, we're going to see it. It needs to be a predictive, not just their closing, but they have to think about what they need to respond to. And I always like to tell the jury, like, Bob and I were talking about what like your little opening quote would be, like everybody, usually they've got like a little mantra that they repeat. And we always like to tell them how the state's going to get up and they're going to talk now and they're going to take what we just said to you and they're going to twist it around and apply it. They're going to use it some other way. There's something else that we always used to like to say. I can't think of right now. That's like, or maybe that was it. Like the state's going to take this quote and they're going to use it again and throw it back at you. But there's things that they can obviously know that the state's going to say in their closing, and they're just going to have to, try to kind of confront it all, having not even heard what they're going to say. But as we're all pointing out, it's sort of obvious what they're going to talk about. There's only so much that they have.
Yeah, look, I mean, there's obviously people out in this world that exist that listen to the entire trial, or maybe they didn't. I don't know, that still think that Karen Reed killed him. Like, they don't give a shit about what anybody said.
But there's no evidence that the vehicle came in contact.
You know what I like about trials is I don't have to know whether or not Karen Reed killed him or not. All I have to do is know that they did not meet their burden. They did not prove beyond a reasonable doubt to me. Other people can disagree. You're fair to disagree, and then that's your prerogative. And I don't give a shit, frankly. Like that doesn't impact me at all. People can call me names and all this other has zero impact on me. Like anything that I read in Twitter, anything that I see and comment, like, I don't give a shit. It's never going to impact what I think. I'm a very independent thinker, and I just don't give a fuck. So they can keep fucking telling me this and this and that. Like, I'm always going to think on my own, and I never have a predisposition as to a goddamn thing. I watched this entire trial, and they did not prove that case beyond a reasonable doubt. End of story. And I'll be stunned. I will be shocked if they come back with a guilty verdict on either of the two primary charges. And that's where I'm at. And
I'm with you, babe. If I'm the defense, I am focusing on, you can ignore all the witnesses. You can ignore the Alberts, the this, the that, the Proctors, the every, and just focus on the last two witnesses of the Commonwealth and the last two witnesses of the defense. And there is no evidence beyond a reasonable doubt that vehicle came in contact with John O'Keefe. And if you believe that, that whatever inverted video tells you everything you need to know about whether or not there was really. Sorry, my computer's about to die. Whether or not there was really
Thanks, Michael.
pieces of the taillight found at the scene, and whether or not that taillight, if the taillight was planted, the DNA was planted. If the DNA was planted, this was planted. If the, but
Like, if I am, I have to be honest. Like, if I am Jackson, I'm not even fucking with that stuff. Like, to be like, you don't need it. They didn't prove their case, and we put on 2 experts that were completely independent of us and the Commonwealth, and they told you. You heard their credentials. Use your common sense. Listen, what you have to balance is Trooper Paul or these 2 guys. That's where your decision lays, ladies and gentlemen of the jury. Trooper Paul or those 2 guys. And if you can't make a decision, that's reasonable doubt. If you can make a decision and you say, well, I certainly believe those guys, that's reasonable doubt. I mean, to me, it's that simple. If you get like stuck, like slogging through the weeds of the conspiracy shit, I think that you could turn jurors off because it's a hard
you have to
swallow.
explain those pieces of the taillight.
I think that they did. I disagree with you completely.
That they planted it.
I think that the cannon shot of the glass could explain the explosion of, like, you're just not digesting that the way you should be.
All right. So you're saying is that he could have thrown the glass at the taillight as she's pulling off, and then we still have no idea, any question in hell as to what actually happened to him after that, but it is wholly independent of him having thrown the glass. Then why in the hell go through the planting? This was planted, that was planted, this was planted, that was planted. If you had to fall back on the whole time the fact that he threw that why not keep asking everyone, well, would you have seen him if he was out there throwing
I think
the taillight?
So to me, it goes back to what a point that you made yesterday, which I thought was brilliant. So it's the cannon shot of the glass. Let's just assume that happens. That John whips the glass. He's pissed off at her, whatever they're arguing about in the car, right? Gets out. He's like, fuck you, Karen. Whips the glass in the back of her car. Unluckily for Karen, hits the tail light. The thing shatters. And then when Lucky does make a pass, okay, and it shoots that snow, when the blade kicks the snow, that's when the taillight pieces get kicked up onto the lawn. I mean, if he's coming down 20, 30 miles an hour in that blade, and we know, he testified that the snow gets pushed to the right.
Right.
So, I mean, it's like, I'm just saying, if it's for me, I am like, man, I'm avoiding getting into the weeds with the conspiracy.
Well, then you're right. They could just say what you just said. They could say, look, let's forget the defense's theory. Let's forget whether or not she was framed. Let's forget the whatever. You put something in there for the defense, the state. And let's just assume that he got out of the car, he threw his glass. But then again, it can't be that either because the freaking glass is up next to his body. You still need to get that glass up near his body after he throws it at the taillight. So I guess you're like, so just as a matter of sheer luck, the glass ends up by the body. Oh, he goes to find it because it is his favorite glass. So I mean, after he throws it, he goes to find it.
If you start to get into all that, that's where you get into your problems, like with this case. Because if she doesn't hit him with the car, then how is he dead?
He fell and hit his head.
Well, I've been putting that out there for 3 months or whatever, 3 weeks, a month. Like that theory to me has water.
They're going to believe a dog interacted with her. They're going to believe that a dog interacted with him, that he got into a fight with a dog, he fell and he hit his head somewhere, somehow.
It's to me, less is more on this closing for the defense. And I don't know if Lana's under the impression that Yannetti's giving the closing. Could
Maybe
be.
he is.
He could be. I don't know any
It's
different.
unusual.
Why? I think
Yannetti did the opening.
He did? Oh yeah, that's true. Yeah, that would be unusual. But he is the Boston. He is the Commonwealth guy. He's the Boston guy.
Right. And I mean, it clearly, I assume Lally is doing the closing. That would be shocking if his co-counsel, we haven't heard word one from, did the closing. But
I mean, in terms of pretrial argument, they both, Yannetti, we saw him. He gave probably the most compelling argument, with the motion, to dismiss. The last one that we saw, he basically laid out their closing right there in that argument. So Van says Jackson is doing the closing. Do you know that, or is that just an affirmative statement that you're guessing? I don't know, because I'm seeing varying. To me, it doesn't make a difference. I think
Grandpa Munster.
I think they're both fine attorneys, and I think they'll both be good. But my thing is that I think less is more. I think the more. I don't know.
I don't want to talk about anybody by name, but I was thinking about two people who I'm not going to name, who said early on that this guy was bending down and his head was hit by the car, that they obviously cannot still think that that's possible, what happened anymore. I heard another person say someone got hit, fell over, and then scraped by a plow and scooped onto the ground or out that far or something. So, a lot of good it does for people to double down on guilt when what they've said thus far is beyond proven otherwise.
Well, I mean, to me, I just think that it's a dangerous gambit if they start digging into all of their theory. Like they did enough during the trial. Like if they start trying to really, really sell the jury on their theory that he was beaten up inside and dragged out, I think it's a mistake.
I do too.
I don't think they need to do it.
I don't either.
And I think that it's a very dangerous thing to do. And the real sad part about this whole thing is that the O'Keefes are never going to fucking know what happened to their son after all the loss they've experienced. And I don't give a shit what people on the outside are saying. The people screaming she's guilty. I saw the evidence. You can't know.
Same for the people screaming conspiracy. We haven't seen that either.
100%. Right. Exactly. I don't know what happened to John O'Keefe. I am sitting here. The evidence.
Neither do the O'Keefes, and that's
and that's what matters. The O'Keefes had to sit through that trial, and it's ending, and they are not going to know what happened to their son and brother. That's the reality of it. And uncle, it's so sad, and and that's where this case is going to lay. And it'll never be any different. I was having debates, like the feds aren't going after these people. Like people are like delusional if they think the feds are arresting the Albert and the McKays. They're not doing that.
I would hope they're looking into that inverted video, though. I'd love to know about that inverted video and who the hell's doing anything about that. How often does and looking at every other Sally Port video to see if it's crystal clear. All of a sudden you got this grainy sack of shit that's inverted. I mean, gosh, I know we've got some Karen Reed is guilty here. Can someone please, I beg of you, I'm asking super nicely, and I will yell at anyone who yells at you for your opinion. Why was that inverted video offered into evidence, and what does it mean to you?
I mean, it could have just been sloppy by Lally. Plain and simple.
By Lally, no. Lally doesn't print videos. He didn't invert it and burn it on the disc.
Yeah,
it wasn't simple to re-switch, or the defense wouldn't have had to go through the trouble of where the numbers stayed. The numbers were then inverted. They would have been able to internally just flop it back.
Yeah, I mean, Carol, I don't know about the butt dials. Like, I have no idea.
They're
Like,
hiding something.
I'm just gonna tell you guys, Allison and I have been dealing with cops for 20 plus years, and they have all kinds of shit to hide. Like, I just don't find that to be dispositive of anything. That cops don't want anybody looking at their fucking phones. I mean, they could be slinging shit on the side. I have no idea. I have
Right.
no
I mean, the
idea.
butt dials are weird, though. The butt dials are weird. The deleted phone calls are weird.
There's
I'm just
definitely
saying it's not, if we're talking proven, nothing's been proven.
there's no question. There's all kinds of shit. Like, the timeline is for shit as far as the Commonwealth goes. That there is all kinds of shady behavior. Like, and it's all circumstantial. Circumstantial of what is the problem? I don't know. Like, I've had so many people in my DMs being like, "Oh, there was somebody in the house that's now in hiding that saw that John O'Keefe was in there," and it's like, dude, that didn't come out at trial, so it doesn't. I don't care about it.
We
It's
did
just,
get steps, though. We did get steps after she got dropped off. Yeah, I mean, that whole timeline thing, that I think that's what they should focus on. You know, now that like Music Jen and Jen and other people are pointing out, they should definitely focus on that timeline. They should focus on the fact that I think McCabe is sending texts like, "Where are you?" At a certain time, where now then they try to testify that they were still sitting outside when we know she was home, and
who,
like,
Karen?
let Lolly just keep getting up there saying at 12:45 this happened at 12:45. At 12:45 she struck him with the car.
I mean, the thing is that Jackson and Yannetti came into this thing, in the press saying we're going to prove that she's innocent. Not that we're not going to win the case and she's going to be found not guilty. We're going to prove that she's innocent.
Well, and smart people could cut their losses and just focus on what they should be focusing on.
Well, I mean, the reality for Karen Reed is her life is never going to be the same, even if she's acquitted on everything. Like everybody that thinks that she's a killer is still going to think that she's a killer. Like, nothing's going to change. A jury verdict doesn't change that at all. Everybody who believed OJ killed Nicole and Ron still believes, even though he's dead. I firmly believe OJ killed Nicole and Ron Goldman.
Yeah, seems pretty likely.
I never didn't believe
but I
that.
undoubtedly would have said not guilty if I was on that jury with that.
I agree. They
racist
didn't
cop
prove it, right?
and all the weird shit with the evidence.
It was that was
the
a shit show.
consciousness of guilt instruction is absurd. I wanted to know, and I was going to actually go back and listen again after we get off of this. What in the hell is the argument that she was hiding the car, like that, so that they couldn't find it? Because that's ridiculous. Like, wouldn't you want to actually hide it inside a garage, at somebody else's house? Or was it something about driving it all around was confusing, was somehow tampering with the evidence? That's what I didn't get, that she was driving it all around to tamper with evidence. Like, but there's no way in hell, there is no chance in hell the judge allowing them argue. I don't know, maybe she actually will let them argue it in closing. She said, allow the Commonwealth to testify to that. So I'm assuming she means argue it, that she somehow had access to the evidence, to the ring camera. I think it's error. I think it's wrong.
I don't think it's going to have that big of an impact on the jury anyway, to be honest with you. Did she like when I jumped off, did Bev admonish the defendant not testifying?
Nope, not in person. I mean, there was no, somebody, I read some comment about them talking to her at the bench and swearing her in, that they may have been asking her there.
Wow. That's unusual.
It's also unusual we didn't hear them renew their motion for directed verdict.
Yeah. They may not have done it.
Now, if they missed that big of a step,
I don't know.
You don't renew it, you waive it.
Why wouldn't it be on the record?
Unless it's not a thing in Massachusetts. So
Lead with love. Thank you, thank you, thank you, thank you for those gifted 10 DD memberships. Michael, love you, man. I love that you're hanging around with us too, man. That's awesome. Michael does tons of stuff with Joe Jackalone.
well, I saw Michael earlier.
Michael's a great cop. Like there's great cops that exist in the world.
I
And
highlighted his.
You get Joe and Michael on here, they'll be the first to tell you that this investigation sucked balls. There's no other way to put it. It was a joke. It's like, had that been like the biggest takeaway from this trial, aside from the fact is that the O'Keefes are never going to find out what happened to their son, is that had they done a proper investigation at all, that we're not here right now, one way or another. Like one way or another, it's like either if they go into the house, they're going to determine either there's evidence or no evidence that John O'Keefe was killed in there or injured in there severely. And if there's nothing in there, then that only leaves two other reasonable explanations: that he slipped and fell, cracked his skull. But if you believe Frank Sheridan, Dr. Frank, he's knocked out, which hurts my theory that he could have gotten up and stumbled to where he ultimately was his final resting place, or he was struck by Karen or a plow. People get hit by plows. You think, oh, Lucky hit him, just didn't know it.
No.
I mean, so I don't know. So thank you, Michael. Appreciate you, man. $20 hollow from Chris 10. If there's not a not guilty verdict, is the case considered closed? Absolutely. Does it go into a cold case pile? Is it reinvestigated? Who decides? No. I mean, there's.
I guess somebody could decide in the future to reopen it. Like if they find something out and somebody says, I want to keep investigating this. I don't think that, but that would be.
I mean, like if anybody out there is wondering if the feds could pick it up on the underlying charges, no, it has nothing that the feds can like lock their teeth into to make it a federal case. You have to be in violation of a federal statute. I mean,
well, they could for some sort of official misconduct, probably.
Well, but that's not the underlying case. That's
right.
Like
right,
they're trying the troopers for like that's a whole different thing.
Right.
But they're not trying them for the murder of John O'Keefe. They're trying them for.
I don't think they're ever.
I don't think I will die on this hill. They're like, this case is done. Once whatever happens tomorrow, it's over. Is what I'm going to predict. So, and if I'm wrong, I'll be the first guy to admit, oh man, I screwed that one up. So, you
don't think the feds are going to do anything with their investigation? You're saying that's different.
What I have read, if I'm to believe what Lally has put in his pleadings, is that despite what we heard regarding their position on that they don't believe that a motor vehicle caused those injuries, they also don't believe. They found nothing to support the defense's theory that John O'Keefe was injured in that house. Like, I mean, that like Lally had that in one of his pleadings. So, I mean, Lally's been known to bullshit. So who knows? But I mean, they both read them.
Well, there's definitely no evidence anything happened in the house because nobody took any evidence from the house.
Right. There's never going to be
any
evidence from the house.
Right.
If they decided not to go into the house. That's always been my point. Like that's why I've said it a million times. If I'm the Alberts and the McCabe's, if I didn't do anything, I'd be furious with these cops. I'd be suing them. I'd be like, your lack of an investigation here. You not coming in and just doing like you didn't even ask me. Can I search the house? Hey man, you mind if we look around? You don't have to go get a warrant. I don't have shit to hide. Yeah, go in, take a look. Like this is the house is the house. I mean, they were standing in there. Hey, can we go take a peek at the basement real quick? Like, I mean, just that's all that had to occur,
Right.
And
but the phone thing, like Bob said before, like the destruction of the Brian Albert and Brian Higgins phones, they could have been hiding anything. An affair. Albert could have been having an affair. He could have been in the evidence room.
All kinds of shit. Well, that's true. Anything.
The amount of porn they watch.
Yeah, like it's their personal phones.
They're like, hell no, am I letting the defense in on my personal shit?
Like, no one's digging in my shit. Not now, not ever. It's like we wouldn't have seen, but like I bet you Proctor wish he had destroyed his shit.
Well, that you can't destroy your if they subpoena your text messages, obviously destruction of the phone doesn't help.
But wait, but you're not going to see the text from the like
They
unless
can
you
if they do it fast enough, they can subpoena the
they didn't
actual
get
text.
Proctor shit for long after. There's no way that they got those text messages from his provider. They had to like Proctor must have still had the same phone. Like that's the only way. Like that, you know that. Like you can't get the body of a text message. Like with AT&T, 30 days, it's done. I mean, you can
It might be
obviously say that
90.
whatever, but it ain't like a year plus. Like that Fed investigation took a long time. And then let's see, reality check $5 holla. Appreciate that. Why wouldn't they point out the footprints at the scene could have been fixed with a rake or a broom? I mean, to me, it's like by the time they went back, when the CERT team gets there at whatever 5:07, whatever it was PM, 5:30 when O'Hara gets back there or whatever. It was O'Hara, right? And I mean, the snow had dumped at that point. Like this whole concept that like whatever
You're not seeing
footprints
any
may have
footprints.
existed
They're gone.
in the early morning hours are long gone, buried under snow.
Right.
I've never understood the
As are the owl pig's footprints.
exactly. The owl pig, the coyote.
Coyote's footprints.
Yeah, well, I'll peek in on
Hey, there's Jay.
where?
Right there.
Jay, where?
Oh, he decided it's not so boring after all.
Oh, what a guy.
Ah,
What a guy. He was just peeking in. He's just
peeking
peeking
in.
in. What's up, J-Bo? So, all right. I think that'll wrap it. Tomorrow, our channel, bright and early for the closings and the verdict. I will definitely do a over under on the length of time we all think it'll be.
We'll think of some polls. We'll think of some polls. Come back, you guys. See us in the morning.
Yeah.
Don't forget to hit the thumbs up on your way out. I'm gonna check right now. I'm gonna see how many likes we've gotten.
Yeah, and thank you to the mods.
Two. There's only 2 thumbs up. No, I'm just kidding.
Wow, that's brutal. Old down with rabbits must have figured out some kind of countermeasure.
Right.
Right,
These 2 assholes.
These 2 jerk offs. I think that might be oh, and just so you guys know, God, thank you so much, Afton. No way, yeah, Afton. Thank you, Afton. So Tuesday night, tomorrow night, I actually have a very big night.
16.
I've got 2 shows going. So I've got our weekly 9 p.m. Central with Bill Dorsch. That's going to be weekly. So that's happening, but it's 6 p.m. and I'll get it out to the world. We are doing a down the hill reunion with with Barb and mods. I've warned you, you guys need to be on high alert for Barb because Barb McDonald, who's a reporter for Court TV and I think is a wonderful person. And I think she does a great job.
And anything that she watches, she's done. Is that the one who has said whatever she does something, the family tends to watch it?
No, that's Susan Hendricks.
Oh, okay.
Susan was the one. No, Barb is, she catches a lot of shit out there in the Delphi world, but I'm not going to let anybody pick on her tomorrow. But it's the whole team who put together the Down the Hill podcast, as well as the documentary that both aired
tomorrow.
Tomorrow night, 6 p.m.
Start marketing it now.
I know. I'm waiting on Dizzy and Mandy.
Oh well,
to finish that thumbnail.
That's definitely.
Well, I kind of did put it in our Discord. Like I gave everybody a lot of notice, but in their defense, I did not get the.
I'll never blame those 2. They work too hard.
I never blame them for anything except for being incredibly awesome. That's the only thing. Oh, Sleuthy, did Barb block you? I mean, I'm sure you deserve it, Sleuth. Kidding. So yeah, so those 2 things. So 6 p.m., 9 p.m. Those are going down. So make sure you're checking those out. And then look, man, it's been like a long break on Delphi. There's been a couple.
Not that much.
Yeah, like not that much, but like we have not given up on Delphi. It was just we were in the middle of this. There's been nothing so pressing that I felt like after a full day of streaming, I didn't need to be a crab ass on a live for 2 more hours bitching at everybody, because
we'll have none of that, please. Sir.
Yeah, exactly. No one needs that in their lives. So mods, thank you for exactly 0 notice of me and Allie going live on this. Thank you to all you guys who decided to jump on and law nerd with us and check out the jury instruction conference. And tomorrow morning, make sure that you're there for the exciting closing arguments in the case against Karen Reed. We'll see where it lands tomorrow, kids. It's going to be a big, big day. So on your way out, please like, share, subscribe, do all that stuff that makes Twitter work, or YouTube work. And follow me on Twitter, Bob Defense_Diaries, and follow Allie. What's your handle on Twitter, baby?
I don't know. Allie Mata, maybe. I mean, I'm just starting to do this again.
She's just a girl on Twitter. She doesn't even know handle.
There probably is someone who's just a girl. Like, I'm just a girl in the world.
Guarantee it.
Yeah.
I guarantee it.
I am.
I think
Allie Law Mata.
Allie Law Mata. There you go. Afternoon.
Afternoon.
All right. So in mods, we love you guys so much, and thank you guys so much for all your incredible generosity today. As always, we really appreciate that, because you guys are what keep us in business. There's no question about it. Hopefully we bring you some decent content. Later.